So, namaste and welcome for the recap. Welcome to the workshop mainly of the Companies Act with respect to directors' provisions, and we'll do a recap of day 3. And the recap is starting from section 169 of Chapter 11. Chapter 11 is appointment and qualification of directors. Of that, section 169 discusses about removal of directors. So removal of directors primarily from section 169 states that by ordinary resolution we can remove a director before the expiry of the person's period and after giving him reasonable opportunity of being heard. Provided independent director who is appointed for second term, if he is to be removed, then we need to pass a special resolution. Then only we can remove. And any directors appointed under section 163 proportional representation, they cannot be removed. This section will not apply in this case. And a special notice is required of removal. That is, a special notice is required of resolution to remove or to appoint somebody in place of a director so removed. Plus, the company shall state the facts of the representations made by the director and send a copy of representation to every member. So what will happen? The person has intimated the board of the company intimates the person, that is a concerned director, then he gives his representation, it's circulated to all. In case the representation is received late, there is not sufficient time, then it is read out at the meeting. And in case the tribunal feels, there's a tribunal order that such representation should not be read at the meeting because it amounts to abusement of rights or abusement of the rights of this defamatory. Primarily it will secure needless publicity for defamatory matter, and so unnecessarily he is going to secure all this defamatory publicity, so better not read any such representations. That is also possible in case the court or the NCLT, that is tribunal, passes an order and the vacancy created by the removal be filled up by the appointment of another director in his place at the meeting at which he is removed. And in case the directors whosoever is appointed in his place, he will be holding office till the time his predecessor would have held office. And if vacancy is not filled up, it is filled up as casual vacancy. So then it is filled up as casual vacancy under section 161, then the board will take care of it. And further, section 170 that discuss about register of directors and KMP. So register of directors and KMP along with the shareholding is required to maintain, and a return in DIR 12 is required to file with ROC within 30 days from the appointment of every director, KMP, and any change taking place amongst them. This section, that is registers, section 170 is not applicable to government companies where entire paid-up share capital is held by the government, which can be either central government or state government. And then once Rule 17 discusses all the contents of the registers, all the details about the directors are required to be provided in the registers. And then we have section 171, that is members have right to inspect. They can come during the business hours, during the office hours, and at the AGM also these registers are available for inspection. And in case if any of the provisions for which specific punishments are not available, have not been mentioned, then non-compliance of any of the provisions of Chapter 11, Section 172 is applicable. That is, company and officer will be subject to fine from 50,000 to 5 lakh rupees. So that's Chapter 11. Then we have Chapter 12. So Chapter 11 we are done with, that is appointment and qualification of directors from Section 149 to 172. Then Chapter 12 starts with Section 173. And of that we saw the important sections, that is, it starts with Section 173, that is meeting of the directors. The very first section is meeting of directors. Then we have Section 174, which discusses about quorum. 175 discusses about circulation, passing of resolution by circulation. So 173, 174, 175 goes together. Meetings, quorum, and passing of resolution by circulation. Then 176 is what we are going to start with today. 176 discusses about primarily in case there's a defect in appointment of the director, then what happens to the cases, to the all the decisions taken before we come to know that there's a defect in his appointment. 177 discuss about audit committee. So 177 is audit committee. 177, 178 goes together. 178 is NRC and SRC. Then 179, 180 goes together. So 179 is powers of the board, and 180 discusses about restrictions on powers of the board. Then 181, 182, 183, all that goes together. 181 is contribution for charitable purpose. 182 is contribution for political contribution, and then we have 183, that is contribution for national defense funds. So that makes it 184. And then we have 184, that is disclosure of interest by directors. And then after that, after 184, 185, loans to directors are also required to be disclosed. So loans to directors. 186, loans and investments by company. And 187, investments by company to be held in its own name. That's 187. 188, 188 is related party transaction, very very important. And 189 is again registers, all the registers of all the contracts in which directors are interested. A special register is maintained for that. So that these are the important sections from this chapter. And yesterday from this section, from this chapter, we did section 173, 74, 75. 173 is meetings of board, and that is first meeting of the board should be held within 30 days of incorporation, and minimum number of board meetings should be 4 in a year, and there should not be a gap of more than 120 days. However, in case of small companies, dormant companies, or OPC, you can have one meeting for every half year. So maximum you will have 2 meetings, and the gap between 2 meetings should be minimum 90 days. Over here, in previous case, it's like there should not be more than 120 days, and in the second case, it should be more than 90 days. That's the difference. And now video conferencing is also allowed in case of board meetings. Now we can have video conferencing, and subject to certain conditions are fulfilled for the video conferencing. And the directors, in case you are having any provisions of video conferencing, you intimate the directors will intimate to you at least before the meeting. He will intimate the chairman or the company secretary, and any notice given by the director that he will be henceforth attending board meetings through video conferencing, that notice is valid for a year. And the notice of the board meeting should be minimum 7 days. In case a smaller notice is given, lesser notice is given, then independent directors must be available, and at least one independent director should be present. In case the resolution is passed, then without independent director, in that case the resolution will be circulated amongst all the directors, the members of the board, and at least one independent director should confirm the appointment. That's what is all about section 173, that is meetings of board. And plus, in case of video conferencing, there are certain items, we can discuss all items in case of video conferencing, but there are certain items which must be done only and only through physical meeting. However, if the quorum is available in that physical meeting, then some other person, some other member of the board or the committee, as the case may be, can attend that meeting through video conferencing. And one more thing, that those members who are attending through video conferencing, they are accordingly minuted in the minutes, and they are also considered for quorum. However, in case there are certain items for which physical meeting is a must, that is which items? FB PA. So in that case, when physical items are must, means physical presence is must in case of FB PA, in that case quorum will be considered only of those directors who are physically present. And FB PA will be approval of annual financial statements. B is approval of board report. So board will always consider when these items when physical board meetings are held. Then approval of prospectus, audit committee meetings for financial statements, and approval of matters relating to amalgamation, merger, demerger, acquisition and takeover. In these cases also we need to have physical board meeting. Then, so that's what we saw in section 173. Then we have section 174, and 174 discusses about quorum for meetings of the board, and that is 1/3 of its total strength or 2, whichever is higher is considered as quorum. In case of section 8 companies, that is charitable companies, the quorum will be either 8 members or 25% of the total strength, whichever is less in that case. And interested directors are not considered for the quorum. And interested directors means those directors are within the meaning of section 184 subsection 2. Further, in case the interested directors are more than 2/3, then 2 directors present will be also considered as quorum. That's all about quorum. Further, as per LODR amendment regulations, quorum of every meeting of the board of a listed entity will be 1/3 of the total strength or 3 directors, whichever is higher, and one of them should be an independent director also present. Then only quorum hoga in case of listed company. And this is which listed companies? Effective from 1st April it was top 1000, and effective from 1st April 2020 it is top 2000 listed companies will have to follow these regulations. That is, a quorum will be at least 1/3 or 3 directors. Of that, one of them will be independent directors. So now in case of top 2000 listed companies as on date, quorum is possible, is available only and only if one independent director is present. If no independent director is present, quorum is not available. And in case no quorum is available, there cannot be any valid meeting. So that's about the provisions we discussed yesterday. And now today we will start with provisions of section 175. So that's a recap done of yesterday.